All right, people. So welcome to Jumbo IAS and welcome to UPSC Prelims Phoenix batch. In this batch, we revise the entire syllabus for UPSC Prelims examination. Now that includes both static as well as current affairs. Now this particular lecture is related to our static lecture series, and in our static lecture series, we are currently covering Indian polity. You're already familiar with this. Now today is day 7 for Indian polity, and our today's targets were, well, Indian judiciary. Well, it includes all aspects of Indian judiciary. That means the Supreme Court, the High Courts, and the subordinate courts. Okay, so we are going to revise all these topics: Supreme Court, High Courts, subordinate judiciary, through a set of 30 MCQs. Now, I'm hoping that, well, the notes that were shared with you well in advance with respect to these topics, you have already gone through those notes, and then you are sitting for this lecture. Okay, I'm hoping that you have already revised those notes. Okay, only then this lecture would be fruitful. All right then. With that hope, let's start today's lecture. Let's begin. So Indian polity day 7, and our today's targets were, well, Supreme Court, High Courts, and lower courts, which we say is subordinate judiciary. Okay. Now, first few questions would be related to Supreme Court, then High Court, and in the end, we'll talk about subordinate judiciary. This would be the chronology that we would follow. All right. So let's begin with question number 1. Consider the following statements regarding the appointment of Supreme Court judges. The President is required to consult the Chief Justice of India in all judicial appointments, including the appointment of CJI themselves. In the second judge's case, the Supreme Court ruled that the advice tendered by the CJI is binding on the President. CJI must consult a collegium of 4 senior-most judges for appointments, and a recommendation cannot be sent to the government even if 2 judges give or disagree with the opinion. Okay, dissent. Now, the thing is that, well, our constitution clearly mentions in Article 124, the constitution says that, well, the president shall appoint Supreme Court judges. And the constitution says that in doing so, the president can consult Chief Justice of India. Okay. Now, here's the thing. Well, there was this question asked well before, many years back, that does the opinion given by CJI, the constitution says consult, does the opinion given by CJI is binding or not? So there were 3 judges' cases in that regard, okay, in the Supreme Court. In the second judge's case, the Supreme Court held that this opinion given by Chief Justice of India is binding. So the president cannot decide on his own. And in the third judge's case, well, the Supreme Court gave further clarity. Well, Supreme Court said that in giving this opinion, CJI shall consult 4 senior most judges of the Supreme Court. Okay. So CJI's opinion shall be based on collective decision by CJI and 4 senior most judges. This shall be called collegium. And if any 2 judges of this collegium disagree with the opinion or a candidature of a particular person, well, that advice won't be tendered. I mean, even if 2 people disagree, that's a veto. And this advice is binding. Now remember, well, the constitution says that if you are appointing a judge of Supreme Court, you have to consult the CJI. But what about appointing the CJI itself? Well, in that regard, the president, well, the convention is that the president will appoint the senior most judge as the CJI. So there is no consultation required. Every senior most judge becomes CJI. So first statement is false, including the CJI themselves is not there. In second judge's case, well, the advice is binding, yes. And in third judge's case, 4 senior most judges. This part is actually correct. Okay. So the answer would come out to be B. Right. Now, this was a very controversial judgment, third judge's case. Okay. Remember this. Now, why was it controversial? Well, the controversy was that nowhere in the world judges appoint themselves. So it was criticized. The collegium system was criticized heavily. So to reform it, well, government came up with NJAC. Now let's talk about the question related to NJAC, then I'll explain further. Regarding the National Judicial Appointments Commission, NJAC, consider the following. It was established through 99th Constitutional Amendment Act 2014. The commission included 2 eminent persons chosen by a committee consisting of President, Prime Minister, and CJI. The Supreme Court struck it down because the veto power of non-judicial members was seen as a threat to judicial independence. Now, listen to me very carefully. to rectify this problem of judges appointing themselves and to rectify the controversy surrounding collegium system, well, the constitution was amended, okay, and article 124A was added, which changed the appointment process, okay. As per this appointment process, all Supreme Court judges shall be appointed by NJAC, National Judicial Appointments Commission, okay. They will give advice to the president and president shall follow that advice, okay. Now 6 people are included in NJAC, okay. Now those 6 people are Chief Justice of India, who shall be the chairman, 2 senior most judges of Supreme Court, then law minister, union law minister. So there now in total there are 4, and 2 eminent personalities, okay, eminent jurists, with eminent people who are legal professionals and all. Now these eminent jurists shall be appointed by a 3-member committee. 3-member committee includes 2 eminent persons, Prime Minister. Look, listen me carefully. 3-member committee includes Prime Minister, Chief Justice of India, and Leader of Opposition. Okay, these 3 people will appoint. Make sense? These will appoint these 2 people. And then this 6-member committee shall, they will decide who will be the judge of Supreme Court. Okay, there was another clause. If these 2 eminent jurists together decide to veto a candidate, that person's candidature won't be forwarded. Okay, so that means somehow these 2 eminent jurists had a veto on the appointment. Make sense? Now let's look at this question. So first statement is correct, absolutely. The commission included 2 eminent persons chosen by a committee consisting of President, Prime Minister, CJ, and Leader of Opposition. So this is false. The Supreme Court struck it down because the veto power of non-judicial members was seen as a threat to judicial independence. So this 99th Constitutional Amendment Act was challenged in Supreme Court. Supreme Court actually set up a 5-judge bench to decide whether this constitutional amendment is valid or not. Okay, and the Supreme Court basically held this constitutional amendment null and void. How? Well, you remember the Supreme Court in Keshav Nanda Bharti case said that any constitutional amendment that alters the basic structure of the constitution shall be declared null and void, right? Now, the Supreme Court held that this veto power with the 2 eminent jurists basically harms judicial independence. And judicial independence is part of basic structure of the Constitution. So hence, this is cancelled. So this amendment was never implemented. Okay, so this is correct. The answer would come out to be 1 and 3D. Right? Next. Which of the following is not included in the original jurisdiction of Supreme Court under Article 131? What do you mean by original jurisdiction? Well, these are those cases in which you can directly approach the Supreme Court. Okay. A dispute between Government of India and 1 or more states? Yes. For this, you'll always go to the Supreme Court. A dispute between 2 or more states involving pre-constitutional treaty? No. Look, a normal dispute between 2 or more states is part of original jurisdiction. But dispute between states with respect to a pre-constitutional treaty or agreement between provinces, that is not original jurisdiction. That case can go to even a high court also. So this is false. A suit for recovery of damages by state against center, high courts can also pitch in this. Dispute related to interstate river waters, that is not original jurisdiction, because for that the Constitution says that we will create a special tribunal for this. So that matter goes to, for interstate rivers, the matter goes to a tribunal, not Supreme Court. So this is also false. So they asked which of the following is not. So 2, 3, 4 are not. Okay, next. With reference to removal of a Supreme Court judge, consider the following statements. The motion for removal can be initiated only in Lok Sabha with the support of 100 members. Special majority required for removal is a majority of total membership of the House and 2/3 majority of members present and voting. The only grounds for removal mentioned in the Constitution are proved misbehavior and incapacity. Now listen to me very carefully. You see, you can remove a Supreme Court judge only on 2 grounds, and these 2 grounds are mentioned in the Constitution. These 2 grounds are proved misbehavior like corruption and all, and incapacity if the judge is mentally incapable or physically incapable. These two grounds are the only grounds on which you can remove a judge. Now, what is the process? So this statement is correct. Now, what is the process? Well, to remove a judge, well, you have to pass a motion in both houses of parliament. Only parliament can remove a judge. Now, that motion can be introduced in both Lok Sabha and Rajya Sabha. Okay. Now, if you want to present a motion in Lok Sabha, you need the support of 100 members, MPs. If you are introducing the motion in Rajya Sabha, you need the support of 50 members. Once the motion has been admitted, well, an inquiry is instituted against that judge who you are trying to remove. Okay, the process is mentioned in Judges Inquiry Act. So what will happen? Then a 3-member committee will be created. Okay, that 3-member committee will have a Supreme Court judge, a High Court judge, and an eminent jurist. This committee shall inquire into the allegations against the judge. Once the allegations, or if the judge is found to be guilty, then the matter would be put to vote. If the motion was introduced in Rajya Sabha, put to vote in Rajya Sabha. If Lok Sabha, then put to vote in Lok Sabha. For that, they require a special majority like this, whatever is mentioned over here. Okay. Then after Lok Sabha or Rajya Sabha, it goes to the other house. Over there also this majority is required. And then finally, if it has been passed, the matter goes to the final signature of the president. That's just a rubber stamp and the judge is removed. Now remember, because the process is so difficult, no judge has been removed through this process so far. Okay. Now, the motion for removal can be initiated only in Lok Sabha. No, it can be initiated in Rajya Sabha with the support of 50 members. So this statement is false. Okay. The answer would come out to be B. Right? Simple. And remember, the same process is followed in High Court also. Removal of High Court judges. Exact same. Okay. Next. Consider the following statements about the writ jurisdiction of the Supreme Court. Okay. The Supreme Court's power to issue writs is exclusive to ensure the protection of fundamental rights. Under Article 32, a person can approach the Supreme Court directly without going through lower courts. The writ of certiorari is issued to order a public authority to perform a legal duty. Now, as far as the writ jurisdiction of Supreme Court is concerned, that power to the Supreme Court comes from Article 32, which says that if a person's fundamental rights are violated, they can directly approach the Supreme Court. Now, remember, Supreme Court's writ jurisdiction is only extended to matters related to fundamental rights. Supreme Court cannot issue writs other than fundamental rights. Okay? And you can directly approach the Supreme Court if your fundamental rights are violated. You can approach a High Court also, but you can also approach a Supreme Court. So this jurisdiction of Supreme Court is not exclusive. People can go to High Courts as well. Okay? And remember, this writ jurisdiction is available only for fundamental rights, not other issues. For High Court, it also includes other issues. Nonetheless, we'll come to High Court. Supreme Court's power to issue writs is exclusive to ensure the protection of fundamental rights. Now remember, this power is not exclusive. Remember, I told you that a person can go to High Court as well. Under Article 32, a person can approach the Supreme Court directly. Yes, directly they can also go to the Supreme Court. They can also go to High Court, but they can go to Supreme Court directly as well without the process of appeals. Now, there are 5 writs. Habeas corpus, which is issued if the person is illegally detained by the police or law enforcement. Mandamus, which is for an administrative authority, to a public authority to perform a legal duty. Okay, if an IAS officer or a government authority is not performing their legal duty. Then there is a writ of certiorari. It is issued against the orders given by lower courts if they have not given right orders or if the matter was not in their jurisdiction. So lower courts and public authority also, they have passed an order. Well, you can cancel that order through certiorari. Prohibition is for lower courts. If a lower court is listening to a matter, they have not passed a judgment, just listening to a matter, and the Supreme Court feels that, well, this is not their jurisdiction, they can't hear this matter, so prohibition is passed. And then is quo warranto, which means, simply put, well, quo warranto means that if a person has illegally occupied any public office, you can pass a writ against that. Now, certiorari is for lower courts. This definition is for mandamus. So this is also false. The only statement that is correct is 2 only. Next. Regarding the advisory jurisdiction of the Supreme Court under Article 143, which statement is correct? The President must seek the opinion of Supreme Court on all questions of law. No. Okay? The President is not bound. The President can, but not must. The Supreme Court is bound to give its opinion on any matter of public importance referred to it. Now remember, writ advisory jurisdiction is when President asks for a legal opinion of Supreme Court and Supreme Court gives its opinion. And since it's advisory, that opinion is not binding on the President to follow. Now remember, the President can ask Supreme Court's opinion on 2 matters. Number 1, well, relating to any pre-constitutional treaty, interpretation of any pre-constitutional agreement, okay, or any agreement during British times, and any other matter. President is free to ask Supreme Court's opinion on any matter. Now, in case of pre-constitutional treaties, well, the Supreme Court is bound to give its opinion. They have to give an advice. In case of any other matter, the Supreme Court can refuse also. We are not giving you any advice. Okay? So, Supreme Court is bound to give its opinion on any matter of public importance? No. Only on pre-constitutional treaties. In disputes arising out of pre-constitutional treaties, the Supreme Court must tender its opinion. The opinion tendered by the Supreme Court is a judicial pronouncement, binding, non-binding, since it's advisory. So, the correct is C. Okay? Next.